Ms. Gilbert and her boyfriend, Mr. Jordan, were in their home, and Ms. Gilbert was getting her hair done when there was a knock on the door. She opens the door, and Mr. Scott enters the bedroom of the residence. He has something under his elbow. He also has something that's in his hand. Our witnesses are going to explain what those items are. Our witnesses are going to explain that when he came in the room, that he hit Miss Gilbert with a hammer from his left hand first. The dog attacks. He hits the dog with the hammer in the head as well. Then he attacks Mr. Jordan as well. What we're going to start with is a list of witnesses, beginning with Dr. Muhammad Khan. Dr. Khan was a treating physician at Fort Walton Beach Medical Center, where Mr. Jordan went to get medical treatment for the lacerations to his head. So Dr. Khan's going to explain that he treated those wounds, and the hospital are the ones that actually called the sheriff's office to respond. Next, we'll hear from Deputy Lacey Stinson. She is the reporting deputy on this case. She comes to the hospital. She talks to Mr. Jordan about his injuries and about how this occurred and who may have done it. We're also going to hear from investigator Brandon Walters. He is the investigator that completed later that day the photo lineup with Mr. Jordan, wherein Mr. Jordan identifies Mr. Scott as the individual that battered both he and Miss Gilbert. We're going to hear from Miss Gilbert. She's going to explain not only what happened that day, but why she didn't come forward when this originally started going through the court system. And finally, we'll hear from Mr. Jordan, and Mr. Jordan will explain that he did come forward at the time. He may not have told the police the full truth at that time, but things changed. Mr. Jordan explained everything later on, and here we are today.
Okay, thank you. Yes, sir, Mr. McKinney.
May I approach the podium?
Yes, sir.
In deciding how to provide an opening at a judge trial, because it's not something that I do a lot of, I looked back at the preliminary instructions that the court normally reads a jury. So at this point in time, I wanted to make sure that we keep track along those things. And to start off with, Mr. Scott is charged with 4 things. We reviewed that slightly in looking at the potential jury instructions, or judge instructions, I believe. There are 4 things to look for. Counts 1 and 2 are each aggravated battery with a deadly weapon. The information alleges a hammer. Those relate to Timothy Jordan and Jennifer Gilbert, who lived at 507 Scott Lane in Fort Walton Beach. Count 3 is a burglary of a dwelling with an assault or battery of that same residence. And count 4 is aggravated animal cruelty related to a dog named KK, who was Mr. Jordan's dog. Those are the things that the state alleges against Mr. Scott that are the purpose for this jury trial or judge trial. And it is going to be your responsibility. And typically the court reads that it's the solemn responsibility of the jury to determine whether or not the state has proved the accusation beyond a reasonable doubt against Mr. Scott in this instance. But in this case, it's going to be the court's solemn duty to hold the state to their burden, to make sure that they present evidence to your honor to prove their case beyond a reasonable doubt. And the court should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, just as we tell juries. And then the verdict that the court renders has to be based on the evidence solely heard in the courtroom, the lack of evidence, and the law. And the court has already touched on that today, that that's what the court intends to do. In every criminal proceeding, the court instructs the jury that the defendant has the absolute right to remain silent. It is at no time the duty of the defendant to prove his innocence. And if he exercises his right to remain silent, we're asking the court right on the get-go to not draw any inference of guilt from the fact that he may not take the witness stand at the end of this trial. We would ask the court not to draw any inferences from the fact that my client is wearing yellow today, that he is here in a jumpsuit. I believe that the court's going to see several witnesses with jumpsuits today, and that's not something that I think the court would draw any inferences from, but that's something that I wanted to make record of. This case is going to relate to an incident back in August of 2021, wherein I believe that the court is going to hear testimony that Mr. Scott entered the residence and that he was normally allowed to do so, and made contact with Ms. Gilbert and Mr. Jordan, who were in a back bedroom of the home, and they are not the sole residents of this home. I believe that there's going to be testimony that numerous people were living in this home and could have opened the door for Mr. Scott to walk in. If that is the testimony that the court hears, then keep in mind the elements that the state has to prove related to burglary. We'll draw your attention to that right there. Whether or not the testimony of Mr. Jordan and Ms. Gilbert is consistent and credible is going to be central to this trial for the state and for the defense to reasonably make argument here. And because there is not going to be any surveillance video or photographs of exactly what happened, so I believe that the court is going to have to rely upon the witness testimony of Mr. Jordan and Ms. Gilbert. And I believe that the court is going to hear some discussion or questioning related to why people's stories have changed over time and what is the truth. And I'm going to leave it there as we move into testimony. Thank you.
Thank you. Yes, ma'am. To the state, your first witness.
My first witness is going to be Dr. Muhammad Khan.
Do you swear affirm the testimony about to give you the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Hi, Dr. Khan. Can you state your name for the record, please?
Mohammed Samad Khan.
Okay. Can you spell your last name?
Yes, Khan.
Okay. And what do you do for a living, Dr. Khan?
I'm an emergency medicine doctor.
Okay. Where did you go to school?
Kansas City University.
And where'd you do your residency?
Allegheny Health Network in Erie, Pennsylvania.
How long have you been a doctor?
In total for about 5.5 years.
You said your specialty is emergency medicine?
Correct.
How long have you been an emergency doctor?
For about 5.5 years.
How long have you been at Fort Walton Beach?
2.5 years.
What's it called now? HCA?
HCA, Fort Walton Destin Hospital.
And that's your current employer?
Correct, through Envision.
Were you on shift on August 12th of 2021?
I was.
Okay. Did you have an opportunity during that shift to treat a patient named Timothy Jordan?
I did.
How did Mr. Jordan present to you?
So, gentleman came in with multiple lacerations to the mostly left side of his scalp, along with forehead.
I'm sorry, Dr. Khan. Can you restate?
So the gentleman came in with multiple lacerations to the left side of his scalp, forehead, and an auricular hematoma on the left side.
What exactly is an auricular hematoma?
Pretty much a blood collection of the ear.
Okay. Forgive me. I think we would call that cauliflower ear.
Correct. That's
Okay. The lacerations to the scalp, can you explain how big we're talking?
some of them were measuring about 4.5 centimeter, 2 centimeter. There was one that was, I believe, 3 centimeter, and there was one on the forehead that was a U-shaped. I believe that was about 5 centimeter.
Would you classify these injuries as significant?
I would say so.
Did these appear to be recent?
Correct. As they were bleeding.
How did you treat each of those injuries?
So the scalp lacerations were repaired with staples. The forehead laceration, I used sutures, if I remember correctly, 5-0. And the auricular hematoma, I had to make an incision to relieve the clot, and then I had to had a pressure dressing to make sure that the hematoma doesn't reform.
What did that incision do for the hematoma?
The reason of the incision was to actually remove the clot in the blood so that it would not turn into the cauliflower, so he would not have a distortion of his ear anatomy. So.
I guess explain to the court exactly what we're talking about in time of how that hematoma works.
Usually after any type of blunt force, you would then develop, it likely caused damage to the capillary blood vessels in the ear and would develop into that hematoma. And the goal is to relieve that pressure and to relieve the blood in the, of course, in the cartilage of the ear. And the reason we do that, of course, and of course this can only be done within the 24 to 48 hours before it turns into that cauliflower.
Did the hospital call the police to speak with Mr. Jordan?
I believe so.
Okay. That's all the question I have. Thank you.
Thank you. Mr. McKinney?
May I have a moment, Judge?
Yes, sir.
Dr. Khan, good morning.
Good morning.
You just stated that the injuries that you treated were recent.
Correct.
Can you give us a better opinion on how recent the injuries were when you treated them?
I'm sorry, as in within how many hours?
Can you give us a medical opinion on how many hours could have taken place, or is that something you could not determine?
I would definitely say it was less than 12 hours because the lacerations and the wounds were still bleeding, and there wasn't any scar formation. So,
Was there any blood clotting?
of the hematoma, yes.
That was related to the ear?
Correct.
Can you give us a medical opinion on what clotting of the blood on the ear would tell us as far as a timeline of when that may have happened?
I would suspect, for me to be able to relieve the clot and relieve the swelling, it would have happened definitely within 24 hours. Otherwise, it would have already clotted off to a point where I could not have evacuated the clot.
Were these injuries primarily to the left side of Mr. Jordan's scalp?
Correct.
Were there any injuries to the back of Mr. Jordan's scalp?
I believe there was one back left.
Do you recall what time you treated Mr. Jordan?
Exactly what time, I'm not sure.
Can you give us an approximate time?
I cannot.
Can you tell us if it was on August 12th?
It was on August 12th.
What would your typical hours be on a shift on August 12th?
Usually about 12 hours.
And when would those 12-hour shifts typically start?
Every shift is different. I just came off a shift today, 2 a.m., so I do morning shifts, afternoon shifts, overnight shifts.
Do you recall if this on August 12th was a morning, afternoon, or overnight shift?
I believe it may have been an overnight shift, but so.
You made reference to this being a blunt force injury. Is that correct?
Correct.
Once again, I'm asking for a medical opinion. Do you think that these type of injuries could have been sustained by a fist?
Possible.
Do you have any medical opinion that you can provide related to what type of blunt force object might have been used?
Not in particular.
I have no further questions.
Thank you. To the state.
Dr. Khan, when you say blunt force injury, what exactly do you mean by that?
Likely something that either, there's two types of injuries that we have, either blunt force or penetrating. Penetrating, something that's sharp, like a knife or an axe, or anything of that nature. Or blunt force could be a fist, could be an object.
So you're just saying blunt force versus sharp force?
Right.
Okay. Thank you, that's all I have.
Thank you. May the doctor be released.
Yes, Judge.
Yes,
Mr. McGinney. Thank you, doctor. Thank you so much. You're released. Your next witness.
My next witness is going to be Deputy Lacey Stinson.
Good morning, please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth?
I do.
Thank you.
Okay. Deputy Stinson, can you state your name for the record?
Lacey Stinson.
Can Can you spell that last name for us?
Stinson.
And where do you currently work?
Okaloosa County Sheriff's Office.
And what's your job title?
Deputy Sheriff.
How long have you had that job title?
4 years.
So you were employed in that capacity on August 12th of 2021?
Yes, ma'am.
Is that how you came in contact with a Timothy Jordan?
Yes, ma'am.
How did you get this complaint?
We received a call from the Fort Walton Beach Medical Center. The hospital called it in.
What did you see when you arrived at the hospital?
I observed Mr. Timothy Jordan in a hospital bed in the ER room. He had lacerations on the right side of his face, a lot of blood on him as well.
Did you have an opportunity to speak to Mr. Jordan after you arrived?
I did speak with him, yes.
When did he say he sustained these injuries?
He said he sustained the injuries.
Yes. The objection is? Yes, ma'am.
It's not for the truth of the matter asserted, Judge, so it's not hearsay.
Okay, what is it for?
It's for laying the foundation for why she took pictures of his injuries and why she went to 507 Scott Lane.
The objection sustained at this point.
Did you take any pictures of his injuries?
Yes, ma'am.
May I approach the witness, Your Honor?
Yes, ma'am.
Judge Simpson, I'm showing you what's been marked as State's Composite Exhibit 1A through D. Do you recognize these pictures?
Yes.
How do you recognize them?
I was the one who took them.
Are they a fair and accurate depiction of the injuries you saw Mr. Jordan on August 12th?
Yes.
Judge, I'd ask that these pictures be moved into evidence at this time.
Without objection.
They're admitted.
Where was this reported to have occurred?
507 Scott Lane in Fort Walton Beach.
Is that home in Okaloosa County?
Yes.
Did you go to the home?
Yes.
What did you examine?
I walked around the yard and I observed what appeared to be blood near the roadway, partially in the yard as well, on some brick pavers.
Were you given any lead on a suspect in this case?
Yes.
And who was that suspect?
I was given a nickname of Kodak, later identified as KENSHAWN Scott.
Do you see that person in the courtroom today?
Yes.
Can you identify him by an article of clothing?
Yes, he's in yellow.
Where's he seated?
He's in between at table 1. Yeah.
If the record can reflect that the witness has identified the defendant, Your Honor.
The record will so reflect.
Deputy, how do you create a photo lineup?
We typically send them off to our analysts for creation.
Is that what you did in this case?
Yes.
When did you do that?
The day it happened, just after I took the report.
Why?
What'd you say?
Why?
In order to identify the suspect.
So you said you sent it to your analyst?
Yes.
That's who creates photo lineups in your agency?
Yes, they can.
What happens after it is made?
After it's made, we typically go administer it to the witness or the victim in this case.
Who administers that lineup?
It can be, it has to be an independent person who doesn't know anything about the case.
So you had a photo lineup created for this case?
Yes,
And that included Mr. Scott?
it did.
Okay. May I approach the witness, Your Honor?
Yes, ma'am.
Deputy Simpson, I'm showing what's been marked as State's Exhibit 2. Do you recognize this?
Yes.
How do you recognize it?
I was the one who had it created, and I was the one who gave it to the independent administrator for it to be administrated to the witness.
So what is it?
It is a photo lineup.
Is it in the same or substantially the same condition as the last time you saw it?
Yes.
So who administered the lineup to the victim in this case?
Investigator Brandon Walters.
Did Investigator Walters help in creating the photo lineup in any way?
No.
Was he familiar with this case in any way?
No.
So did you have any conversation with Investigator Walters about the identity of your suspect before he administered the photo lineup?
No.
Which number is the defendant in this lineup?
Number 3.
I don't have any other questions, Your Honor.
Okay. Thank you. Yes, sir, Mr. McKinney.
Deputy Simpson, good morning.
Good morning.
When did you start your investigation and speaking with Mr. Jordan at the hospital?
Are you asking for an approximate time or?
Yes.
Okay. I believe the report call came out at around 2:50 a.m. That was when I started the investigation.
Would it refresh your recollection if you looked at the CAD report?
Sure.
May I approach the witness, Judge?
Yes, sir.
Do you recognize that document?
I do.
Does it refresh your recollection as to when the call came out?
It does.
And what time was the call?
The call came out at 2:44.
Is that when you were on scene with Mr. Jordan at the hospital?
No.
You would have responded to the hospital from that point?
Yes.
And that is approximately 2 o'clock or 2:45 or in the morning, right?
Yes, I actually responded at 2:45, yes.
In the morning.
Yes, 2:45 a.m.
May I approach the witness, Judge?
Yes, sir.
When you spoke with Mr. Jordan at the hospital, was he able to convey to you a version of events of what happened?
Yes.
Why was there no investigation related to KK the dog?
The KK the what?
The dog.
I was not given any information about a dog.
Did you do any investigation related to a burglary?
No, I did not.
After speaking with Mr. Jordan, you went to 507 Scott Lane
I did.
and you observed what was in the front yard.
Yes.
Did you find evidence consistent with the story that Mr. Jordan gave you at the hospital?
I did observe what appeared to be blood in the yard.
That was blood spatter in the front yard?
Yes.
Or did you speak to any witnesses that saw what happened?
At the time, there was no information that I had a witness. It was just him.
Did you do any investigation at that point related to Miss Gilbert?
I did not have any contact with Miss Gilbert, no.
Why was there no investigation at that point related to Miss Gilbert?
Because Mr. Timothy Jordan did not relay any information that anyone was on scene or anything about a dog at the time of my investigation.
And I'm talking about Jennifer Gilbert,
Yeah.
a person.
Mm-hmm.
So there was no investigation related to Miss Gilbert or the dog?
No.
And that was because of the original statements of Mr. Jordan?
Yes.
Was Mr. Jordan able to communicate clearly with you while you were at the hospital?
Yes.
Did you search 507 Scott Lane for a hammer?
I did look in the front yard, yes.
Did you find a hammer?
No.
Did you find any blunt objects that would have fit the story for Mr. Jordan?
No.
I have no further questions.
Thank you. To the state.
No redirect, Your Honor.
May the deputy be released?
She can remain.
Okay. Yes, ma'am, if you'll step down, but if you'll remain in the courthouse. Your next witness.
Call Investigator Brandon Walters, Judge.
Good morning, please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Investigator Walters, can you state your name for the record?
I'm Investigator Brandon Walters.
And can you spell your last name for us?
Walters.
Were you employed?
I am employed with the Okaloosa County Sheriff's Office.
And how long have you been there?
Just maybe a couple days short of 9 years.
What's your current job title?
I'm an investigator.
What was your job title on August 12th of 2021?
I was classified as an investigator. I hadn't moved over yet, though I was still acting on the road as they were calling me an invested corporal at the time. This is guys of a split duty thing, but that was a corporal, essentially.
Investigator, have you ever administered a photo lineup?
Yes, ma'am.
Did you have an opportunity to administer a photo lineup to Mr. Timothy Jordan?
Yes, ma'am.
How did that come about?
I was contacted by Deputy Stinson, said that she had a case that she needed someone to present a photo lineup for.
Did you have any conversation with Deputy Stinson about this case prior to administering the lineup?
No, ma'am.
When did you administer the photo lineup?
I believe it was the night of August 12th of 2021.
Did you know which one of the pictures was a suspect when you administered the photo lineup to Mr. Jordan?
No, ma'am.
Was Mr. Jordan able to pick out a person from the photo lineup?
Yes.
May I approach the witness, Your Honor?
Yes, ma'am.
Investigator Walters, do you recognize that?
Yes, ma'am.
Is that your signature?
Yes, ma'am. I'm on the witness box.
What is that?
That is me confirming this is the photographic lineup affidavit form. This says that if they're able to make an ID or not.
Is that the photo's initials mean on that photo?
That means that that's the individual. He put his initials there along with the date. That is the identifying the individual. That is the person who did whatever the crime was at the time.
Judge, at this time, I would like to move State's Exhibit 2.
Mr. McKinney. 2 is admitted.
Investigator, are you issued a body camera for your duties?
Yes, ma'am.
Were you wearing that body camera at the time you made contact with Mr. Jordan?
Ma'am.
The timestamp correct on this body camera footage?
Actually, on the video itself, it says later. I think it was possibly like 5 hours or so.
May I approach the witness, Your Honor?
Yes, ma'am. And I'm sorry, investigator. So the time on the body cam shows 5 hours later than when it was taken, or 5 hours earlier than when it was taken?
Later.
Okay, thank you.
May I approach, Judge?
Yes, ma'am.
Investigator Walters, do you recognize this?
This looks like the copy of the video that I signed on your office last week.
Just to be clear, this is going to be State's Exhibit 3. So how do you recognize that?
It's got my initials on it from after I reviewed it.
So what is it?
It's a copy of my body camera footage from when I administered the photo lineup.
Is it in the same or substantially the same condition as the last time you saw it?
Yes, ma'am.
Judge, at this time, I'd like to move this video into evidence and publish it.
Mr. McKinney?
Without objection.
It's admitted. If you'll let me know when you're ready. I'm going to have to power off the audio because it's not allowing me to route the video. So let's reboot it. Okay, good.
It's not reading the external speakers.
Okay. You want me to ask for IT?
You said you turned them off?
No, ma'am. I had to reboot the system, but everything should be up at this point.
Plug it back in.
Okay.
We just do it as line in?
You have a phone? No, I have a phone. I got a phone.
I'll take the call over back to you right now.
Oh, okay. Thank you.
Try that one.
That phone does a lot of good. It's not plugged in, did it?
Yep.
Phone? Nope. That's
Which
interesting.
one? So, videos.
Go to audio.
Yeah, I just unplugged it.
No, I mean,
It
like,
won't come up. Yeah, it won't do anything when I hit that.
Oh, that's as far as it goes.
Thank you, sir.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
I hear a difference in when you play it. Why don't you let it run a little bit and see if audio picks up?
It's coming through the computer.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at Hub City.
This to you real quick, okay? You will be asked to view a group of photos of individuals. The person of interest may or may not be present in the photograph array, and the photographs are not in any particular order. The lineup administrator does not know the suspect's identity or location in the photo array. It is just as important to exclude innocent persons from suspicion as to identify the perpetrator. You should not feel you have to make an identification. Take as much time as you need to look at each photograph. If you do identify someone, the administrator will note your exact words regarding your identification. Individuals presented in these photographs may not appear exactly as they did at the date of the incident because of features such as head and facial hair are subject to change. We will continue to investigate the incident with or without an identification by you. After viewing all the photographs, if you can make an identification, please circle, initial, and date the photograph of the person you have identified. Since this is an ongoing investigation, you should not discuss this photo array or the results. Take as much time as you need to examine them. Okay? You understand? Okay? I get you to initial here that you understand what I read to you and the instructions. Okay? Did the individual instruct you in this photo line? Is that him or does it look like him? Okay, can you circle it, please? Initial and date as well. What's today's date? 12. 8/12/2021. Okay? All right. Since you're done with the lineup now, what I need for you to do is I would give you a photograph of 6 photos, okay? So you were able to select somebody, correct? Can you check that box, please? Okay, and you've selected photo number 3, and that's the person who did what? Okay, all right, what I need for you to do is if you swear this is true, everything is good, and you did this voluntarily, I'll get you to sign right there for me, please, sir. All right, thank you, sir. I appreciate it.
Investigator Walters, just to be clear, what did you do with the photo lineup after Mr. Jordan made his selection?
I put it back on the dash of Deputy Stinson's car and released it back to her.
I don't have any questions, Your Honor.
Thank you. Mr. McKinney?
Investigator, good morning. What we just saw on video was from your body cam
Yes, sir.
that was provided to the state last week?
I couldn't tell you about who I didn't present it to him. Must have been Deputy Stinson.
Okay. Where was that at?
Or was what?
What we just saw in the video?
It's 507 Scott Lane.
And was this after Mr. Jordan was released from the hospital?
Appeared to be since he had his head bandaged, yes, sir.
And this was on the 12th of August?
Yes.
Do you know approximately what time?
I believe, if I remember right, around 10:50 p.m.
May I have a moment, Judge?
Yes, sir.
Were you able to communicate clearly with Mr. Jordan? Was there anybody else there with Mr. Jordan outside 507 Scott Lane?
I believe there was a couple people in the yard, but I could not tell you off the top of my head. I couldn't see them in my video, and I obviously never had any contact with him. Other than I did go out there earlier to try to make contact with him to see if he was there and how he was not home at the time. And there was 2 people in the yard.
You went out earlier on August 12th to make contact with Mr. Jordan. Was that for this incident or for another incident?
This was to see if he was home, so that way I could try to do a photo lineup, to do the photo lineup with him, but he was not home.
So was this on the day of is this lineup on the day of the incident or not?
Well, yes.
No further questions.
Thank you. To the state?
No other questions, Your Honor.
May the investigator be released?
Yes, Judge.
Okay. Thank you, investigator. You're released.
Thank you.
Why don't we take a 10-minute recess and then we'll come back and finish up the morning, okay? Thank you.
All rise. Court's in recess for 10 minutes.
Specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Thank you. Ms. Gilbert, can you state your name for the record, please?
Jennifer Aaron Gilbert.
Can you spell your last name for the record?
Gilbert.
Ms. Gilbert, are you a convicted felon?
Yes, ma'am.
How many times?
5 times.
Have you ever been convicted of any misdemeanor crime of dishonesty?
No, ma'am.
So you've never been convicted of any crimes of dishonesty?
Like the misdemeanor?
Right.
Oh, 2.
Ms. Gilbert, where were you living on August 12th of 2021?
Scott Lane, Fort Walton Beach, Florida.
Do you know what number on Scott Lane?
507.
Who are you living there with?
Timothy Jordan.
Is that home in Okaloosa County?
Yes, ma'am.
Were you home on August 12th of 2021?
Yes.
What were you doing that day?
I was in the bedroom getting my hair cut.
Was anyone there with you?
Timothy Jordan was in the room. I was getting my hair cut and everything. I'm
sorry. It's okay.
I was in there getting my hair cut, and we had stopped back from going to the condo for a week. So.
Who else was in the room besides Mr. Jordan?
Sierra Sheffield and Kyle.
Who's Kyle?
He is a barber.
Gilbert, did something unusual happen while you were getting your haircut that day?
Yes.
Okay. What happened first?
As I'm sitting there getting it done, I see Mr. Scott come in the room. He had a hammer in his left hand. And
did he have anything in his right hand?
He had a towel. He had his right hand underneath his left hand.
I see you making some movements on the witness stand. Can you explain a little bit better of what?
Yeah, okay. He had a hammer in his left hand, and in the right, he had a towel over over his right hand. So I thought he got,
Where was his right hand with that?
right under his, like right here.
So like under his side, under his elbow arm.
Yes, ma'am.
So kind of tucked in between his arm and his side.
Yes, ma'am.
Gilbert, do you need some water or something?
No, I'm trying to scoot back in the chair.
What happened? Well, let me just back up for a second. Okay, you said that you saw who with these items?
Mr. Scott.
Okay. Can you identify Mr. Scott by an article of clothing?
Right here.
Can you identify him by an article of clothing?
Any regular clothing?
What's he wearing right now?
Yellow.
If the record can reflect that the witness has identified the defendant.
The record will so reflect.
What was the defendant's street name?
Kodak.
Okay. So let's just call him Kodak while we're talking today, okay?
Yes, ma'am.
Yes, sir.
I would object to my client being referred to as Kodak through the remainder of the question.
Okay. Why?
Judge, I believe if we go to 403 balancing test, whether that's overly prejudicial to read the street name rather than Mr. Scott's actual name, I have 403 balancing concerns.
Okay, the objection sustained.
Okay, so we'll call him Mr. Scott while we're being here today. Okay. So you saw Mr. Scott come into the room.
Yes, ma'am.
What happened when he entered the room?
He hit me in the head with the hammer. And
where did he hit you?
Right here.
Is that on your forehead?
Yes, ma'am. My forehead.
Kind of the left side of your forehead. Okay. What happened next?
After he hit me in the head with the hammer, he went straight out from under his left arm. He pulled out a gun and faced it toward Jordan, Timothy Jordan.
What hand did he have the gun in?
In the right hand. And KK, the pit bull, grabbed his arm and pushed it like away. And he hit KK on top of the head with the hammer too.
How many times did he hit KK in the head with the hammer?
One time.
What happened after he hit KK with the hammer?
He pointed the gun at Timmy, and when there was enough time for Sierra, myself, to get out of the room, we did. And KK followed right behind us, the pit bull.
What arm did KK attack of Mr. Scott?
The right arm.
What happened next?
I left, so I don't know. I had blood coming down me, so I don't know really what happened after I was exited out of the room.
So you said you had blood coming down your face?
Yes, ma'am.
Where was that from?
From getting hit had a hammer.
So you were injured from the attack?
Yes, ma'am.
I'd like to show you what's been marked as State's Composite Exhibit 4A and B. May I approach, Your Honor?
Yes, ma'am.
Gilbert, do you recognize these pictures?
Yes, ma'am.
What are they?
The picture of my forehead.
Are they a fair and accurate depiction of the scar you sustained, the injury to your forehead, the impact?
Yes, ma'am.
Judge, at this time, I'd like to move State's composite exhibit 4A and B into evidence.
Mr. McKinney?
No objection.
They're admitted.
Ms. Gilbert, did you go to the hospital?
No, ma'am.
Why not?
Because I was terrified if I did that he would probably come back and do more damage to myself and Timothy Jordan and KK.
So how did you treat the wound to your head?
I went to a friend's house and they bandaged my head up.
Did you call the police?
No, ma'am.
Did you do anything to report this?
No, ma'am.
Why?
I was scared.
Scared of what?
Mr. Scott, afraid you might come back and retaliate again.
I don't have any other questions, Your Honor.
Thank you. Yes, sir. Mr. McKinney? Yes, sir.
Ms. Gilbert, good morning.
Good morning.
You just testified that this happened after you had been away at a condo for a week?
Yes. We were coming back.
Were you and Mr. Jordan on vacation?
Yes, sir.
Who lived at 507 Scott Lane on August 12th?
Myself, Timothy Jordan, and this guy named Blue that lived there.
Who is Blue?
He's like a friend of friend of ours that's in the front room.
Do you know Blue's name?
Dennis or something.
Who else lived at 507 Scott Lane?
Just us three.
Did Blue know Mr. Scott?
Yes.
From your testimony today, is that the first time you saw Mr. Scott on the 12th is when he entered a bedroom in the home?
He used to come over and hang out for a little while and then leave and get water for us and everything.
So that would be on other occasions that Mr. Scott would come over to the house. On this day that you're saying you got hit in the head with a hammer, the first time that you saw Mr. Scott, based on your testimony that you gave today, is that he came into the bedroom. Is that correct?
Yes, sir.
Do you know who let Mr. Scott into the house at 507 Scott Lane?
I don't know.
Was Mr. Scott welcome at the house at 507 Scott Lane?
We never told him no, he could not come over.
Okay, so that's an ambiguous answer. Was Mr. Scott able to come to the house or not?
Yes.
Was Blue in the room with you in the bedroom when Mr. Scott entered the room?
No, sir.
Was he home that day?
He was in the front room.
Is that where the front door is?
Yes, sir.
Where was the dog when you were getting your hair cut?
In the bedroom with us.
In the bedroom?
Mm-hmm.
Was Mr. Jordan on the bed?
Yes, sir.
Where was Sierra?
On the bed also.
With Mr. Jordan?
Yes.
Is there only one entrance into this bedroom?
Yes, sir.
And KK is a pit bull, is that correct?
Yes, sir.
So did KK immediately go for Mr. Scott when he entered the room?
No, after I got hit with the head of the hammer, that's when she attacked him.
So when Mr. Scott entered the room, was he in the room?
Yes.
Fully in the room before this happened?
Yes, sir.
Was there any conversation before you're saying that you were struck in the head?
No.
How long was Mr. Scott in the room prior to you being hit in the head?
Not long.
Is that not long as in seconds or minutes?
Like maybe 5 seconds. He was in the room. 5 to 10 seconds he was in the room.
And absolutely nothing was said before you were struck? How many times were you struck?
1 time.
And your testimony today is that the pit bull, did the pit bull jump and bite Mr. Scott?
When she heard me scream, that's when she got up. And he was pointing the gun at Timothy Jordan.
You said that the pit bull, I don't want to put words into your mouth, latched onto Mr. Scott's arm, his right arm, is that correct?
Yes, sir.
Did the dog have to jump to get to his arm?
KK was on the bed, and when he went like that, she just jumped up and grabbed his arm and pushed his gun away from Timmy.
Did the towel drop when Mr. Scott made that motion?
Yes, sir.
And what happened to the firearm when the dog bit Mr. Scott?
I don't know. I was already out of the room.
How close were you to the door?
I was right next to the door.
And were you sitting in a seat?
Yes, sir.
And was Kyle right next to you?
Yes, sir.
Do you know Kyle's last name?
No, sir.
Did the gun ever discharge?
I was already out of the room, sir. I don't know.
So you were out of the room very quick?
Yes.
Did Kyle leave the room with you?
Yes, sir.
Did Sierra leave the room with
Yes.
you? Did she jump up from the bed?
Yes.
And did the dog let go of Mr. Scott and leave with you too?
Yes, sir.
Did the KK, the pit bull, did KK die from this event?
No, sir.
Did the dog leave with you?
Yes.
Did you take the dog to a veterinarian?
No, our friend also, she just got hit 1 time, top of her head.
So the dog went with you to a vehicle and you left?
Yes.
Did you see an altercation between Mr. Jordan and Mr. Scott?
I was already out of the room.
So you never saw Mr. Scott strike Mr. Jordan with anything?
No, sir.
If you were indeed terrified of Mr. Scott, why wouldn't you go to the police to do something about it?
Because I was scared to retaliate and come back and do something worse to us. I was in fear for my life.
Did you ever see a doctor after this?
No, sir.
Judge, may I have a moment?
Yes, sir.
Ms. Gilbert, was there someone named Donnie in the house too?
No, he was outside, pulled up when I was already out of the house.
Do you know Donnie's name?
I just know him as Donnie. I know his last name.
Who did you leave with?
Juice.
Who's Juice?
One of the friends that we know.
Was he also at the house?
No.
Did somebody call Juice to come pick you up?
No, he was going down the road so we saw him and pulled him over.
So did you flag down this person and get a ride to a friend's house?
Yes.
Instead of going to the hospital? Is that a yes?
Yes, sir.
Did you leave with Mr. Jordan?
No.
Did you go with Mr. Jordan to the hospital?
No, sir.
When's the next time you saw Mr. Jordan?
It was after he went to the hospital.
What time did this occur?
At nighttime.
Do you recall if this had happened shortly after sunset or at a good ways into the night? Can you give us any direction?
Like in the mid, about between 7 and 8, like right as it got dark. It was dark already. It was already dark outside.
Is your answer right after it got dark?
It was a little after when it got dark out there.
I have no further questions.
Thank you. To this state.
Ms. Gilbert, you were saying that your friend did something to your dog?
She put went outside and put 80 ointment on top of Kiki's head.
So your dog was injured from this event?
Yes.
Can you explain the injury?
He got hit in the top of the head with a hammer.
What did the injury look like to her head?
Like a round circle on top of her head.
Did she appear to be in pain?
No, ma'am.
Did she appear to suffer in any way?
I mean, when you would come in the room or even like get close to me and Timmy after this happened, she was like very on point more.
Ms. Gilbert, I just want to make clear, what changed that you decided to come forward at this point?
Because what if he did it to somebody else and worse? I would, want to do the right thing, I mean, it's not, that kind of what they might be able to do to the next person. If someone else made it to somebody else, what would happen to them? It could have been worse.
I don't have any other questions.
Ms. Gilbert, I've got a couple questions. One, I think you mentioned, and I may have written this down incorrectly, that Mr. Scott came to the house previously, and you said something in relation to water?
Yes.
What did you say?
He would go get water for us and come back with no problem. We had no problem with him ever being over there. He never told me he was not allowed there. When this happened, it was like out of the ordinary.
Okay.
It was a shock.
And then regarding KK, what was the result of KK being hit by the hammer?
She basically also deal with like PDS because she got, after that, she got very more alert and was always on point and like always trying to either reach towards me or Mr. Jordan. She would like not growl, but like kind of growl a little bit at you. So you couldn't even get close to the end of the bed at all after this happened.
Okay. What about physically to her head? Anything?
The top part of her head, she had more on top of her head.
Okay. Is it still there?
She might have a little scar.
Do either of the attorneys have questions for Ms. Gilbert based on the court's questions?
They are. No, Judge.
Okay. Thank you, Ms. Gilbert. Does Ms. Gilbert need to remain at the courthouse, or can she be taken back to the jail?
If she can remain.
Okay. Thank you. Thank you, Ms. Jordan. Ms. Gilbert, I'm sorry, Ms. Gilbert. Your next witness?
Mr. Timothy Jordan, Your Honor.
Thank you.
Good morning, please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Mr. Jordan, can you state your name for the record?
Timothy Richard Jordan.
Okay. Can you spell that last name for us?
Jordan.
Mr. Jordan, are you a convicted felon?
Yes, ma'am.
How many times?
7 times.
Have you ever been convicted of any misdemeanor crimes of dishonesty?
What's that?
Any kind of theft charges or
No, ma'am.
bad checks?
No.
Mr. Jordan, where were you living on August 12th of 2021?
At 507 Scott Lane,
What city is that in?
Fort Walton Beach.
Is that home in Okaloosa County?
Yes, ma'am.
So that home is where you would stay overnight,
That's where I lived.
but you stayed there overnight?
Yes, ma'am.
Okay. Were you home on August 12th of 2021?
Yes, ma'am.
What were you doing that day?
Laying on my bed in the bedroom.
Was anyone there with you?
Yeah, my bedroom was full of people.
Who all was in the bedroom?
I had a professional barber there cutting my girlfriend's hair, and
What's his name?
Kyle.
Who else?
I know Cassandra Kessinger was there. A girl, Sierra was there. She was pregnant. My girlfriend Miranda was there. She's dead now. And there was just a bunch of people in there.
Mr. Jordan, did something unusual happen while Miss Gilbert was in the bedroom with you and all these people?
Yeah, Kyle was cutting her hair, and Kodak came through the door with a sheetrock hammer and a gun in his hand.
Is Kodak a street name?
Yeah. All I know him by is Kodak or Scott.
Okay. Do you know the person before
Personally?
that day? Yeah.
Yes, ma'am.
Okay. Do you see that person in the courtroom today?
Yes, ma'am.
Can you identify him by an article of clothing?
He's right there.
Is it something that he's wearing?
He's wearing yellow.
Judge, if the record can reflect, the witness has identified the defendant.
The record will so reflect.
So you saw Mr. Scott come into the room.
Yes, ma'am.
What happened when Mr. Scott entered the room?
A gun went off. My dog KK latched on to him, and he swung a hammer like 1 or 2 times and hit Jennifer in the head or somewhere. And then just pandemonium broke out. People started running out the room, and I came off the bed, and everybody had pretty much left but me, him, and the dog. And me and him, he started hitting me with the hammer.
Okay. All right, let's walk through this a little bit better, okay? Can you explain what the gun looked like?
It was a black Glock 17 with an extended clip.
Was that gun familiar to you?
No, I'd never seen it before.
Was that gun something that was in your house?
No, ma'am. The guns that were taken out of my house were drug task force got them.
You said the hammer, it was a sheetrock hammer?
Yes, ma'am.
Had you ever seen that sheetrock hammer before?
Not really.
So was that hammer something that came from inside your house?
I don't think so, but there was all kinds of stuff. There's all kinds of stuff in my house.
Did you know Kodak was coming over that day?
No, ma'am.
Were you familiar with Mr. Scott before that day?
Yes, ma'am.
How were you familiar with him?
Well, we was in jail together, and after he got out of prison, he came to the neighborhood, and I tried to look out for him.
Was Mr. Scott living with you at this time?
Not at this time, but he was before this happened.
About how long before this happened that he was no longer living with you?
Probably about a week.
Had you told Mr. Scott whether or not he was invited into your residence?
No, he stabbed a dude on my front porch.
When did that happen?
Objection.
Yes, sir.
Before we get into the facts of another event, I would say relevance.
Okay. Yes, ma'am. Why is it relevant?
Because he's testifying that Mr. Scott was not allowed at his residence.
The objection's overruled.
So when did that happen?
About a week before this happened.
What did you tell Mr. Scott at that point?
That he wasn't allowed at my house. I couldn't have all that around my house. I had enough.
Okay, so You said that Mr. Scott came into your bedroom.
Yeah, he busted through the door.
Did you see him as soon as he entered?
Yes, ma'am.
Okay. Was he holding any objects at that time?
I told you he had a hammer in one hand and a gun in the other.
Which hand was the hammer?
I'd say his right.
Okay.
Yeah, because he went like that and hit Jennifer with the hammer.
Okay. And what was in his left hand?
The gun.
Tell me what happened next.
Well, like I say, he hit her 1 or 2 times, and then it's like the door moved far enough open and people started charging for the door, and they was running out of the room, and then he turned his attention to me and started hitting me with a hammer.
What happened when his attention went to you?
He started hitting me with the hammer.
Did anything happen before he started hitting you with the hammer?
The gun was already out of his hand. The dog got that.
Okay.
But all he had when he turned his attention to me was his hammer.
So what happened when he came after you?
He hit me multiple times in the head with the hammer.
Where did he hit you?
All over there. He hit me in my head, on the side. He messed up my ear to where they had to drain it at the hospital. That's really what made me go to the hospital.
So were you injured from this attack?
Oh, yes, ma'am.
Right. I'd like to show you what's been marked as State's Composite Exhibit 1A through D. May I approach, Your Honor?
Yes, ma'am.
I ain't know it was that bad.
Mr. Jordan, do you recognize these pictures?
Yeah, that's me.
Are they a fair and accurate depiction of the injuries you sustained from that attack?
Yes, ma'am.
Which I think we've already admitted these in evidence. So you went to the hospital following this, is that correct?
Yes, ma'am. There's people, I wasn't going to go, but people said that the police was looking for me.
Were you honest with the hospital about what happened?
No, I wasn't.
Did you call the police?
No, I didn't.
Did you speak to the police?
I had to at the hospital. The police came there to see me.
Did you tell the police the complete truth about what happened?
No, I didn't, because I didn't want them going in my house.
So what details did you leave out?
I told them that I was attacked in the front yard.
Why?
Because I didn't need the police in my house.
Why?
Well, I go to trial June 19th in Santa Rosa County for trafficking in over 28 grams of fentanyl.
So what were you doing to make money at this time?
Allegedly selling drugs.
Was Mr. Scott familiar with you selling drugs?
Yes.
Did you make a lot of money selling drugs?
Drug task force took over $10,000 from me about 3 weeks after this happened.
So was Mr. Scott familiar with you having a large amount of money in your possession?
Yes, ma'am.
Mr. Jordan, Why have you decided to be honest now?
Ain't no sense in keeping up with a lie.
So what changed?
Time to turn a new leaf.
What do you mean by that?
I don't know really. I've never been given a chance in the court of law. Every time I walk in the courtroom, since the age of 16, I've always got the book thrown at me. At the age of 16, I went to prison for 40 years for pretty much the same thing that he did to me. And I've never got a break in this courtroom. I've always been sentenced to the maximum amount of time I could receive.
Have you been promised anything to make these statements today?
You can't promise me nothing. I'm facing 25 years minimum mandatory in Santa Rosa County.
I don't have any other questions, Your Honor.
Thank you. Mr. McKinney?
Mr. Jordan, good morning. Who all lived at 507 Scott Lane when this happened back in August?
Pretty much anybody that didn't have nowhere to go.
So you kept your doors open to try to help people out?
Yes, sir.
And you opened the door to Mr. Scott for him to live at 507 Scott Lane, is that right?
Yes, sir.
Up until the week before this happened?
Yes, sir.
Did Blue live at the house too?
Yes, sir.
At the time? Do you know if Blue let Mr. Scott in the house on the date that this happened?
I can't say who let him in the house, because I was in my bedroom.
So where you're at in your bedroom, you have no way to see who's coming in the front door?
No, sir.
You described Mr. Scott busting through the door of the bedroom and then a gun being discharged. Is that accurate?
Yes, sir.
Did that happen at the same time?
Pretty much.
Did that happen prior to Miss Gilbert
yes, sir.
being struck? Was KK or Miss Gilbert struck first?
Miss Gilbert was struck first.
Is that why KK latched on to Mr. Scott?
KK is very protective of Miss Gilbert.
Where did KK latch on to Mr. Scott?
Onto his left hand.
Onto his left hand?
Yes, sir.
You said that the dog got the gun. What did KK do with the gun?
Well, I mean, when KK lunged at him and got his hand, he dropped it.
Did that clear the room? Everybody run?
Pretty much, it was a stampede trying to get out of there.
Did KK leave with the people?
A little bit afterwards, yes. KK took off after Jennifer.
Did you see KK get hit with a hammer?
Yes, sir. KK got hit 2 or 3 times.
Did KK die from this event?
No.
Did KK leave with Miss Gilbert?
Yes.
Obviously, I know you're in jail, but who's in possession of KK today?
It's Willie Simmons' dog. His wife, Sierra, was in my bedroom. She was pregnant with his baby.
Was KK still alive and well?
Yes.
Did KK suffer any lasting injuries from this event?
No.
Can you describe for the court, were you on the bed when this happened?
Yes, sir. I had just laid down.
Can you describe for the court what you did when Mr. Scott came in through the door?
Well, at first I was shocked. And then after he hit her and he went to turn around towards, and him and KK were going at it, because KK was right there on the end of the bed. And then he hit KK, I mean, right in the forehead, and she backed up. And then he went to turn his attention, and I had set up on the bed, and then that's whenever he hit me with the hammer, and KK came back at him again. And
if I stop you for a second, Mr. Jordan, did you go after Mr. Scott, or were you still laying on the bed?
I was setting up on the bed by that time.
And it was while you're on the bed that you got struck with a hammer?
Yes, sir.
Did you fight with Mr. Scott?
Yes, sir. I got up off that bed.
And what happened from there?
I took him from the bedroom to the hallway.
Was there?
I got the hammer out of his hand, and we went from the bedroom to the hallway.
Did you continue the fight in the hallway?
Yes, sir.
What time did this happen?
Late afternoon. I mean, I don't...
Was it still light out when it happened?
Yes, sir.
How long was it before you were dropped off at the hospital?
A long time. Because when Donnie come in and he took off out the door.
Now, who is Donnie?
Donnie Herbst. He's a friend of mine that lives down the street that I used to live with.
Was he outside the house when this happened?
From what I heard, he drove up, and before Jennifer jumped in the vehicle that she jumped in and left, she told Donnie that Donnie was coming down the street, and Jennifer ran out to him and screamed to him that Kodak came in the room and with a gun and all this. They thought I was dead. And Donnie parked his truck and came in the house. And I had Kodak against the wall between the other bedroom and the bathroom.
Did you leave with Donnie?
Yes. I put a towel over my head, locked the house up, and I left.
Was there anybody in the house when you locked it up?
Nope. There was nobody in that house when I locked it up and left.
And your testimony is that you didn't want anybody in, you didn't want police in the house.
I didn't need them in my house.
Did the police ever come look in the house at any point?
Nope.
Did somebody clean the house up?
While I was at the hospital, they did.
Do you know who did?
Jennifer, Sierra, and probably Sue.
So your story that this happened in the front yard, when you spoke to police at the hospital, you knew that was a lie at the time?
Yes, sir.
But what you've told the judge today is the truth, not what you told police when you gave your statement.
Is honest to God's truth what happened.
May I have a moment, Judge?
Yes, sir.
where did this firearm end up going? Or do you know?
I couldn't tell you.
You
I
said
got
that
back to the
after
house. The house was clean, and I don't know where it went. Drug cap task force kicked my door in. They got a Mossberg 12-gauge pump shotgun, and they got a silver Taurus 9mm.
But not a Glock 17?
No.
Where did the hammer go?
I couldn't tell you.
You didn't have the hammer when you left?
When I left my house, I went to Donnie's, and I sat there, and I got higher than Pluto trying to make the pain go away, and I sat there until they said the police was looking for me everywhere, and everybody that was there just finally made me go to the hospital.
Was that the same day? Just later in the day when you went to the hospital?
I didn't go to the hospital till late that night. I don't know what time I went to the hospital, but I know they had to make me go.
I have no further questions.
Thank you. Redirect.
Jordan, forgive me. You said that the hammer was in his right hand, but the gun was in his left hand. But while you've been on the stand, you've been motioning opposite. Are you sure which hand we're talking about here?
This is my right hand.
You've been motioning when you speak about the gun with your right hand.
No, the hammer.
Okay.
Because when he came through, he hit Jennifer like that. The gun was in this hand, towards this way.
Where did he strike Jennifer?
Upside the head, upside the face, somewhere. Because as soon as he busted through the door, Jennifer stood up. And that's what caused her. He came and hit her with his right. The hammer was in his right. I know where the hammer was at.
So at that point, Miss Gilbert was in between you and
In my
Scott?
bedroom, when you come through the door, I had a bench right there, like a old oak table, but a real short one. And Jennifer was sitting on that, and Kyle was right behind her cutting. He had just started cutting her hair. And she couldn't have been 3 foot from the door. Because I know Cassandra and Miranda ended up behind the door.
You said KK was hit in separate times. Is that right?
Yeah, when he hit KK the first time, KK backed up and then shook it off and came back at him again.
I don't have any other questions.
Okay, thank you. Thank you, sir. You can step down.
Okay.
You wish for him to remain in the courthouse?
Yes, Judge.
Okay, thank you. Thanks, Mr. Gilbert. Your next witness?
Judge, at this time, the state would rest.
Okay. Mr. McKinney.
May I first podium?
Yes, sir.
Judge, as we move into a judgment of acquittal argument,
yes, sir.
When I opened this morning, I laid out that there were 4 different charges. Count 1 is an aggravated battery with a deadly weapon. Count 2 is an aggravated battery with a deadly weapon. Count 3 is a burglary of a dwelling with an assault or battery. And aggravated animal cruelty. If I start at number 4 and work backwards, related to aggravated Animal cruelty requires the state to provide the court evidence that Mr. Scott intentionally committed an act to an animal and that his act or failure to act resulted in excessive or repeated infliction of unnecessary pain and or suffering to the animal, or the animal's cruel death. That is not the testimony we've heard today, even in the light most favorable to the state. We would ask the court to grant a judgment of acquittal for count 4 related to the aggravated animal cruelty. I don't believe that survives the judgment of acquittal. Count 3 is burglary of a dwelling with assault or battery. We would present to the court that we don't believe that the state has met their burden related to burglary within this set of facts, and that even in the light most favorable to the state, that this case should not survive a judgment of acquittal related to burglary. There's been no testimony of Mr. Scott coming into the home. If the state has to prove that he had the intent to commit a crime at the time that he came into the home, there has been no testimony at all related to Mr. Scott coming into the home at all. Everything we've seen today, or heard from today, has Mr. Scott coming into the bedroom, and that he had previously lived at the home the week prior, and that there was another roommate present in the front area of the home that would have been in a position to let Mr. Scott into the home without incident. We would ask the court to grant a judgment of acquittal related to count 3. Counts 1 and 2 related to the aggravated battery with a deadly weapon. We will defer to the court to make a judgment of acquittal finding on counts 1 and 2 based on that there has been testimony related to battery and testimony related to a hammer. May I approach?
Yes, sir.
Judge, the court has the jury instructions. I'm not going to approach with those given that the court has those.
Yes, sir.
The court has a copy of the amended information, so I'll defer to the court.
Okay, thank you. To the state.
Judge, as for the aggravated animal cruelty charge, Your Honor, what the state would argue is there has been evidence that's been presented through the testimony of Ms. Gilbert and Mr. Jordan that Mr. Scott's act resulted in the excessive and repeated infliction of unnecessary pain and suffering to the animal. We heard from Ms. Gilbert that KK still has a scar on his head from being struck in the head with a hammer. We heard from Mr. Jordan that not only was the dog hit that first time with the hammer, but then he was struck, or she was struck again as Ms. Gilbert had exited the room. So I think that would show the excessive and or repeated infliction of unnecessary pain and suffering to the animal. And Ms. Gilbert also explained that KK still suffers from I think the words that she was trying to get out were PTSD, Judge. So that would go to show as much as I think you could possibly show that the dog is still suffering. As far as the burglary charge, Judge, what the state would argue, it sounds like that the only basis that the defense is asserting a judgment of acquittal is on element 2, that at the time of entering that he had the intent to commit an offense inside the residence. What I would point the court to is the testimony that especially the Glock 17 with the extended magazine, that was not something that was to be found within Mr. Jordan's residence. So what I would point the court to is that Mr. Scott had the intent when he entered the residence with that gun, that he intended to commit a crime when he entered the residence. This was not a gun that he just picked up as he walked through. Now, Mr. Jordan also explained that Mr. Scott had been a resident of, at least temporarily, of 507 Scott Lane. He was no longer a resident of 507 Scott Lane, and he was no longer allowed at 507 Scott Lane. Now, even if Your Honor doesn't believe all of that, we still, if Your Honor believed that he had the ability to be in that residence by invitation or license, well, in this particular case, we're talking about, at this time, he was entering the residence with the intent of deceit by hiding this gun so that way it couldn't be seen. So he was intending to commit a crime when he entered the residence, Your Honor. Now, I think the two aggravated battery charges, from my understanding, it was a movement for a judgment acquittal based on the hammer not being a deadly weapon. Now, deadly weapon is defined that any object that will likely to cause death or great bodily harm. And so at this point, what we're talking about is Dr. Kahn's testimony first thing this morning. He explained that the injuries, especially to Mr. Jordan, are significant. So we can see from the evidence that's been presented of the pictures of Ms. Gilbert's forehead. She still has quite a significant scar to her forehead. We can see from the pictures of Mr. Jordan from the hospital, we can see quite extensive injuries to his head. Dr. Kahn specified in his testimony that one of the lacerations was about 5 centimeters long, and the other one was another approximately 4 centimeters long. Those injuries, we would submit to the court that those injuries are great bodily harm in and of themselves. So we would say that the deadly weapon is qualified just based on the evidence that's been presented today, Judge.
Okay, thank you. If I can have the exhibit.
Yes, Judge.
Thank you, ma'am. Please, thank you. Thank you, ma'am. Thank you. And I was going through the jury instructions to see if the court at this point finds that the state has proved its burden, at least as of this stage, and the court does find that, so respectfully, the motion for judgment of acquittal is denied. Mr. McKinney?
Judge, I think it would be appropriate to have a comfort break at this time, and I'd like to speak with Mr. Scott prior to coming back and addressing the court.
Okay, do you need 15 minutes?
10 minutes.
Okay, we're in recess for 10 minutes. Thank you.
All rise. Court's in recess for 10 minutes.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks.
Mr. Scott to ask any questions.
Right, it wouldn't be testimonial, right? Okay. So, Mr. Scott, and I was thinking about this a lot during that break. For 14 years, I've read jury instructions, and what I tell defendants when a jury is deciding the facts is I say, do you understand that you have the right to testify and not testify? Do you understand that? Okay. And in those instances, I say, here's what I read to the jury if you decide not to testify. And here's what I read if you decide to testify. And I was thinking about printing those off, and I said, no, let me tell you what those things say and what I think, because I'm the fact finder. If you decide well, first off, if you decide to testify, I would treat your testimony like I would any other witness witness's testimony. I don't add anything to it. I don't subtract anything. I just treat you like any other witness. So that's what my ground rules are, what my instructions are. That's what I think if you decide to testify. So do you understand that?
Yes, sir.
And if you decide not to testify, then I don't hold it against you. You have the right to remain silent. I'd be a hypocrite if I didn't really believe that, because I've told probably 100 juries or more that. And I believe it every time I tell them that because it's true. I certainly do not hold it against you if you decide not to testify. So do you understand that?
Yes, sir.
Do you wish to testify?
No, sir.
Okay. Mr. McKinney, and let me ask you one other question. Have you had sufficient time to speak to Mr. McKinney about your right to testify and not to testify? Okay. Mr. McKinney, you wanted...
Judge,
yes?
to be clear, the state would disagree with Mr. McKinney's position that showing the court his arms would not be testimonial. That would be testimonial evidence. It's just, it would be physical that the court would be viewing. So for one,
it would be evidence, but I don't know if it's testimonial. I think about hearsay and those things, that verbal would come to mind, but I think it would be entered into evidence. It would be something that the court could consider as evidence. Is that what you mean?
it's still offering testimony to the court in a fashion, Judge. I don't know how that evidence would come in without offering some kind of testimony to the court.
To explain what I'm seeing.
Yes, Judge.
Okay. Because there hasn't been anything to this point that would give the court any context of any physical characteristics of the defendant, correct?
That's correct, Judge. There was no testimony that there was any claim of marks bleeding something from the defendant in order to justify just showing some kind of arms to the court.
Okay, so your objection to the court looking at Mr. Scott's arms or anything like that is what? What's your objection?
I don't believe that he would be able to keep his right to silence and offer testimony at the same time. He's offering a testimonial evidence to the court at that point that would be up for any kind of cross-examination.
Okay. Mr. McKinney?
I believe that the state is arguing that the court can't look at Mr. Scott because the court can look at Mr. Scott and see his arms from the bench. What I'm proposing is not asking Mr. Scott any questions that could be cross-examined by the state, but simply asking Mr. Scott to sit arguably closer to Your Honor to show him his arms, which Your Honor can see right now from the bench. I don't believe that is testimonial in nature, and I believe that doesn't open the door for the state to be able to then cross-examine Mr. Scott related to anything at all.
Okay. Anything else?
Judge, there's no way that the defendant can offer evidence in this case without being able to be cross-examined by the state.
Okay. The objection from the state is overruled. Mr. Scott, if your attorney wants you to stand in front of the court, in front of the lectern, and show me your arms.
I'll ask for him to be able to approach the court security.
That's fine. Just right there I can see. Okay. Thank you, sir. Thank you. Okay. Mr. McKinney. Okay. Closing arguments to the state. Are you ready to do those now?
Yes, Judge, we can go ahead forward.
Okay.
Judge, at this point, Mr. Scott is is charged with 4 counts on the information. We'll start with count 1, the aggravated battery with a deadly weapon. So at this point, we're looking at jury instruction 8.4, that the defendant actually intentionally touched or struck, in this case, Mr. Jordan, against his will. And in doing so, he used a deadly weapon. Your Honor has heard briefly my arguments, I think, regarding this issue when we were discussing the JOA. At this point, what has been presented is that Mr. Jordan has testified and Ms. Gilbert has testified, as well as Dr. Muhammad Khan, Deputy Lacey Stinson, and Investigator Brandon Walters. Now, what we started with this morning is Dr. Khan. He explained that Mr. Jordan presented to the emergency room with pretty serious lacerations to his head and ear regions. We've introduced pictures from at the hospital that were taken by Deputy Stinson of the injuries. It was like before that his head was stapled, his forehead was stitched, his ear was drained of the blood that was pooling in the ear. Dr. Khan explained that this was a recent event, that it was less than 12 hours that the laceration had happened. So that's why it was still actively bleeding when Mr. Jordan had presented to the hospital. He explained that these were evidence of blunt force injuries. Now, he explained the sizes of those injuries, anywhere from 2 centimeters up to 5 centimeters in length, which you can see in the pictures that have been presented to the court. At that point, the sheriff's office was called to the hospital where Deputy Lacey Stinson arrived, and Deputy Stinson questioned Mr. Jordan about what happened. Mr. Jordan at that point identified that it was Kodak, or Mr. Scott, that was the person that caused these injuries to him. Mr. Jordan left out details, and he's very clear today that I did leave out those details at the time of my speaking to law enforcement. Mr. Jordan was a drug dealer. Mr. Jordan was dealing drugs. Mr. Jordan had a lot of money. Mr. Scott knew he had a lot of money. So Mr. Jordan was clear even at that point that the person that actually intentionally struck him with a sheetrock hammer was Mr. Scott. So, Your Honor, we would submit to the court that at this point the state has proven the aggravated battery against Mr. Jordan. Now, as far as the next charge, which is also an aggravated battery, that's against Ms. Jennifer Gilbert. Now, we had the opportunity to hear that at that point we knew that this was Mr. Scott, that was the person that had harmed Mr. Jordan, but we didn't know at that point that Ms. Gilbert had also been harmed, because Mr. Jordan, as he was clear with the court today, he didn't say that she was a victim. So it was only Mr. Jordan that had the opportunity to do the photo lineup with Investigator Walters. Ms. Gilbert didn't have that chance. Ms. Gilbert explained to the court today that she didn't come forward right away because she was, as she said it, scared to death. She was scared of Mr. Scott retaliating, and so she didn't come forward until a later time. But luckily for her, things changed, and she's now come forward, and she's explained to the court that Mr. Scott actually intentionally struck Ms. Gilbert in her forehead, and in doing so, a deadly weapon was used. She explained that Mr. Scott hit her across the forehead with a hammer. We have pictures where Ms. Gilbert still has a very significant scar across her forehead. So next I want to talk about the animal cruelty charge. before we move on to the burglary. In aggravated animal cruelty, the state has to prove that Mr. Scott intentionally committed an act to an animal that resulted in the excessive or repeated infliction of unnecessary pain or suffering to the animal. The testimony for this particular crime comes from Ms. Gilbert and Mr. Jordan. We hear Ms. Gilbert explain that KK still has a scar on his head, that he was hit in the head with a hammer after she had been struck in the head with a hammer. She explained that they had to dress the wound because it was apparently an open cut to the top of his head. She explained that her demeanor has now changed, and the dog now suffers from what it seems to be a type of PTSD, showing the suffering that KK endured from this. Now, Mr. Jordan explained that not only was KK struck that one time, but as Ms. Gilbert was leaving the room, KK was struck at least once, if not twice more. So that's where we're going to see the second part of the aggravated animal cruelty charge, that the defendant's act resulted in the excessive or repeated infliction of unnecessary pain or suffering to the animal. So that's where we get to that bridge of it being a repeated action.
Wait, I'm sorry. Tell me, okay, what is the second prong I have to find?
That the defendant's act resulted in the excessive or repeated infliction of unnecessary pain or suffering to the animal.
Okay, yes ma'am. Okay, thank you.
The last charge that I'd like to discuss is going to be the burglary of a dwelling with assault or battery. At this point, how it's charged is that Mr. Scott made a battery upon Mr. Jordan upon entering his residence. Now, the state does not have to prove that we know exactly how Mr. Scott got in the residence. We don't have to prove that he climbed through the window. We have to prove that he entered the residence with the intent to commit a crime therein. So at this point, what Mr. Jordan has explained is that at minimum, the Glock 17 that Mr. Scott was holding when he entered the bedroom, at minimum, that Glock 17 was not something that was in their residence. Meaning Mr. Scott had the intent, by bringing that firearm within that residence, he had the intent to walk through the door, say nothing to the residents inside that room, and start hitting people. We know Mr. Jordan had a large amount of money. We know Mr. Scott knew that Mr. Jordan had a large amount of money. Now, so at this point, Judge, the testimony has been presented to Your Honor for all four charges, and the state feels confident at this point that we've proven beyond a reasonable doubt that Mr. Scott is guilty of all four crimes.
Thank you, ma'am. Mr. McKinney?
Judge, may I first report you?
Yes, sir.
Judge, I'm going to start with 3-9, the evidence, which is an instruction that's normally read to a jury. And considering what Your Honor has heard today by way of testimony, the court should consider whether or not the witnesses had the opportunity to know about the things that they testified to, whether or not their memory was accurate, whether or not their answers were honest and straightforward when talking to the attorneys, but also whether or not it agreed with testimony given by other people today. Ms. Gilbert and Mr. Jordan gave different stories of the same event. We can't necessarily go with statements made by Ms. Gilbert to law enforcement because she didn't make any. She was not even involved in the original investigation. The court should consider whether or not their statements are inconsistent when determining whether or not there is a doubt that's reasonable here. And we'll end with 3-7 in asking the court to ultimately determine that the state has not provided enough evidence and there are doubts that are reasonable, and that the court should find Mr. Scott not guilty on all 4 counts. But if we look at the evidence specifically, and I'll work my way backwards again. If we start with the aggravated animal cruelty, the state has to prove that Mr. Scott intentionally committed an act to an animal and that his act resulted in excessive or repeated infliction of unnecessary pain and suffering to the animal. Without an expert to testify what the dog is thinking, I don't think that we can necessarily jump to a diagnosis for PTSD on KK. I do not believe that there has been evidence that supports a finding that Mr. Scott is guilty of excessive or repeated infliction of unnecessary pain and suffering to the pit bull. Ms. Gilbert said that the dog was struck once. Mr. Jordan had a different version of events in that the dog was struck multiple times. In both versions of events, the dog leaves the room and leaves with Ms. Gilbert. Ms. Gilbert says that the dog leaves immediately with her when she runs out of the room. Mr. Jordan says that the dog stays longer and fights with Mr. Scott. In both of those sets of events, even though they're different, the dog walks out of the room. The dog is not dead. The dog is not necessarily in any pain. Neither of the witnesses, Mr. Jordan or Ms. Gilbert, testified today that the dog was in pain or realistically suffered. There are doubts abound as to whether or not this is excessive or repeated infliction of unnecessary pain and suffering on the dog. The court should find Mr. Scott not guilty as to count 4. Count 3 is the burglary charge. I would argue that the court has at its disposal a lesser included offense of trespass whenever the court really identifies or discusses burglary. That's fairly normal in dealing within the burglary instructions and statute. But we don't even necessarily have that here because the testimony of Ms. Gilbert is that Mr. Scott would routinely come to the house. The state has to prove that the time of the entering of the dwelling, they had the intent to commit a crime. There has been no testimony of what Mr. Scott was doing when he entered into the home at 507 Scott Lane. There's been no testimony of who let him in. There has been testimony that there was a roommate that was in the front that could have let him in, and that by the person by the name of Blue that we don't know his real name. The state is forwarding an argument that this Glock 17 is really important to this analysis, and I believe that it's not. Meaning that there has been no testimony about where this Glock 17 came from, inside the house, outside the house, whether Blue handed it to him or he didn't. These are all doubts that are reasonable as to whether or not Mr. Scott is guilty of burglary. If the court finds Mr. Scott guilty of burglary, then has to determine if a battery occurred as part of the burglary. And within the instructions, it says if you find the defendant guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt in the course of committing the burglary whether or not he battered any person. A battery is an actual and intentional touching or striking of another person against that person's will, or the intentional causing of bodily harm to another person. The argument from the defense is this is not a burglary at all. But the charges are burglary with a battery, and there's at least a temporal break of Mr. Scott walking into the house and then walking into the bedroom. The walking into the bedroom is completely different from Mr. Jordan to Ms. Gilbert as well. And that is an inconsistency that the court should note. In Mr. Jordan's version of events, he bursts through the door and a gun goes off. That's a set of events that is pretty memorable, I would say, without having the right words for it. In Ms. Gilbert's version of events, Mr. Scott walks in the door and then hits her in the head with a hammer while concealing some sort of a firearm under a towel. That's a completely different set of events. In Ms. Gilbert's set of events, no gun ever goes off. That it's the act of her getting hit in the head that cues everybody to leave the room. And Mr. Jordan has a completely different version of events. Both Mr. Jordan and Ms. Gilbert are convicted felons. That's something the court to consider when weighing the evidence. Ms. Gilbert has 2 crimes of dishonesty. That's also something the court can consider. But what's more important here are the inconsistencies between their 2 stories, which gives rise to reasonable doubt. Ms. Gilbert was fairly definite that he had and she even showed the court that he had a hammer in his left hand and his right hand was concealed, and she made a point of showing the court exactly what that was. Mr. Jordan was also very certain of the exact opposite, that the hammer was definitely in his right hand, and in his left hand there was a firearm. So the stories diverge from the very beginning of Mr. Scott coming into this room, actually. So to circle back around, we believe that the court should find Mr. Scott not guilty of the burglary count. That leaves us with 2 counts of aggravated battery. And related to those, both Mr. Jordan and Ms. Gilbert testified that Mr. Scott hit them with a hammer. The court was able to see the demeanor of Mr. Jordan and Ms. Gilbert from the stand, and was able to hear their stories, which is what the state wants this court to rely upon in making a decision. And I would point to 3.7, that reasonable doubts may arise from the evidence, they can arise from conflicts in the evidence, which there are many, and an overall lack of evidence. There was no crime scene investigation done because Mr. Jordan didn't want people in his house. The court, even though he wasn't prompted, learned about Mr. Scott's home being raided by a drug task force later. He didn't want people in the house. Somebody cleaned up the house before he even got home. He stated that that was likely Ms. Gilbert and the other people that were there. Mr. Jordan says that this happened in the late afternoon when it was light out. Ms. Gilbert was pretty confident that it was dark out in the 7 to 8 o'clock range, shortly after sunset. That is pertinent for the court to decide who's telling the truth here, because we know that Mr. Jordan was not truthful when he was approached by law enforcement at the hospital. One could say he sent them on a goose chase and told them a completely different story. When they went out to the home, they did an investigation and looked around the yard. They saw blood on the yard, blood spatter. They did not see a hammer. They never saw a firearm. And they never looked inside the house based on what he told them. At that point in time, there was no mention of KK. There was no mention of Ms. Gilbert. Mr. Jordan was doing what he could to cover himself, to keep law enforcement from going inside his house. What has changed between now and then, other than being incarcerated? I don't know. But it's not up to the defense to present that to Your Honor as the fact finder here. But it does call into question whether or not he's telling the truth to the court today. Given that there was wild inconsistencies between Ms. Gilbert and Mr. Jordan, somebody has to not be telling the truth. The court can consider that. That is a reasonable doubt. It's on that basis that we would ask the court to not find the testimony of Mr. Jordan and Ms. Gilbert competent and credible. And we would ask for the only just resolution here, which is a not guilty verdict related to counts 1 and 2, the aggravated battery. Thank you.
Thank you, Mr. McKinney. To the state, finally, anything else?
Judge, Mr. McKinney briefly explained that there's the potential for a trespass lesser included. Now, we have a long way to go before we get to just a trespass lesser included. We have quite a few different types of burglaries that can be alleged long before we ever get to just a trespass. We've got everything from armed burglary of a structure for entering the bedroom armed with a sheetrock hammer and a firearm, all the way down to just a burglary of a structure without any kind of armed or battery or anything involved. So there's a lot to be considered before we just throw the word trespass out there and then leave it and never talk about it again. As far as the weighing the evidence, and Judge, yes, Ms. Gilbert and Mr. Jordan are convicted felons. They made no bones about that. But we, as a court of law, I mean, prostitutes can be victims of rape just as much as drug dealers can be victims of burglaries and batteries. That doesn't change anything as far as what their allegations are at this point. The allegations are that Mr. Scott entered their house and then into their bedroom. He had a gun, he had a hammer when he entered that room. Very quickly, this all occurred. Very quickly, Ms. Gilbert is struck in the face, and as she explained today, she has blood running down her face as she's trying to then leave the room. So very quickly, she exits the room, and then her dog is attacked. I know there was, Mr. Scott made a big showing of showing his arms to the court to show that there's no marks. There wasn't any allegations from the victims that KK, when he bit, that he broke the skin. I think that just goes to more credibility for what the witnesses presented today. They didn't say that KK bit down and broke the skin. That there was no allegations that Mr. Scott screamed out in pain. There was nothing like that. The allegation was from both of them that when KK went after Mr. Scott's arm, that he struck KK in the head with the hammer. That's when KK sustained the injuries. Now, I heard Mr. McKinney suggest that we need an expert to say that the dog has sustained injuries. I'm not sure if the allegation is from the defense that we need to have a dog whisperer that, to channel the dog's inner thoughts. I'm not sure if that's what they're trying to make the state hold their burden to, but I would be hard pressed to find some kind of case law that would back up that type of argument from the defense. No. So at this point, Judge, we still believe that the state has proven beyond a reasonable doubt each of the 4 charges that have been alleged in the information.
Okay, thank you. Security just asked me to take a short break before I announce my ruling, so I'll just step out back, and if you'll just let me know when you're ready, I won't push a button or anything. So we'll just take a short recess, and then I'll come back in and give you my ruling. Thank you.
All rise.
In the courthouse on Crestview Historic Main Street, we serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Linear as far as the way that I express them, but Mr. McKinney in his closing argument said, about the discrepancies in the testimony. I certainly heard that, but I look back at my notes, and Mr. McKinney was exactly right. When Mr. Jordan testified, he said that you entered the room, a gun went off, and then you swung the hammer at Miss Gilbert. So I wanted to verify that was the sequence. Also, as I was looking at the jury instructions before I took the bench today, it was probably yesterday, looking through the jury instructions, had not looked at any facts, didn't know anything about it, but I was curious when it got to the burglary. Some of those defenses to that are that you were lawfully on the premises, you were invited in or had some invitation that was ongoing, and that you stayed longer than your invitation was good for. And so I was curious to see if that was going to come into play today, and Mr. McKinney brought that into play as far as the history, but there's a bright line that makes it easier for the court. The bright line when Mr. Jordan said, approximately a week before this incident, you stabbed a dude on the front porch, and so he wasn't allowed to come back to the house. That's consistent with his thoughts of why he didn't want the police there, but I was really curious about how that was going to go. The only thing I wrote down during opening statements, because it's not facts, it's not testimony, the only thing I wrote down was what Mr. McKinney stated, beyond a reasonable doubt. I wanted to make sure, and that's in the jury instructions, an aggravated battery, beyond a reasonable doubt. That's a really, really high burden. And so I wanted to make sure that I kept that in the forefront of my mind while I was listening to all the testimony before I make my decision. It's a really high burden. The instruction that we read to the jury says it's not a mere possible doubt or a manufactured doubt. So I understand those definitions, but a high burden. Looking at aggravated animal cruelty, and when I took so long before ruling on the motion for judgment of acquittal, I do rulings with pink highlighters. Whenever I take notes in civil hearings and things, and I go back to before I make my rulings, I use a pink highlighter to say, yep, I found this and this and this. And so that's what I was doing on the jury instructions. So looking at aggravated animal cruelty, I find that you did intentionally commit an act to an animal. And then when I look down at what did that act do, it says that I must determine beyond a reasonable doubt that you knowingly and intentionally, and it's tortured. It's got a disjunctive or tormented, but tortured and in so doing injured. So then I think tortured. So I have to look at definitions. The definition of cruelty and torture include an act wherein unnecessary pain or suffering is caused. So I certainly find that unnecessary pain or suffering was caused by you hitting the dog with the hammer. So I do find aggravated animal cruelty. On the aggravated battery, again, beyond a reasonable doubt, I find that you actually and intentionally touched or struck against their will both Mr. Jordan and Miss Gilbert. And it's disjunctive. I don't have to find both, but I also find that you intentionally caused bodily harm to them.
Sorry, Judge, is that great bodily harm?
It's just, I'm going through the instruction. Then the next thing I have to do is, in committing the battery, so that's the definition of battery. In committing the battery, do I find that it was great bodily harm? And I look at the definition for that. Great bodily harm means, well, and it's interesting, it tells what it's not. Means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. So from that definition, the injuries to both Mr. Jordan and Miss Gilbert were not slight were not trivial, were not minor, and I don't find them to be moderate harm. So in committing the battery, you intentionally caused great bodily harm to both of those victims, certainly to Mr. Jordan, and you caused a permanent disfigurement to Miss Gilbert. When she walked up, I could see from the side of her face immediately, even before she testified about the indentation on her forehead. If that isn't enough, you also used a deadly weapon, but you didn't use that deadly weapon to commit the battery. You used the hammer. So I don't think that I have to find, and I don't find that you, well, I'm sorry, strike that. I do find that you used a deadly weapon, because the definition of deadly weapon is an object that will likely cause death or great bodily harm if used Let me finish the definition. Likely cause cause death, I don't find that. Great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. A hammer is not designed for that. However, an object not designed to inflict bodily harm may nonetheless be a deadly weapon, and this I do find. If it is used in a manner likely to cause great bodily harm. Hitting someone with a hammer in the head, certainly this court finds is a deadly weapon. I do find that the touching was intentional. On burglary, first, I'll look at the definitions to determine whether the elements are fulfilled. It talks about licensed or invited into the structure. Again, that was made easier for the court to find that that was not the case. You were not invited into the premises because of that bright line approximately a week before this incident. It says, I may infer, because it talks about the intention as an element of the mind, and so the court can infer, the fact finder can infer that you had the intent to commit a crime inside the structure if you entered the structure without the consent of the owner. And I find that. So that is an inference that then makes it easier for the court to find that you entered a structure owned by another person. And at the time of the entering of the structure, you had the intent to commit a crime in there that wasn't a trespass or a burglary. It was a structure you entered in the course of committing the burglary. You committed battery on two people that were there. At the time you entered, you were armed. The definition of dwelling is a structure that is designed to be occupied by people lodging therein at night. I do find that the structure was a dwelling. There were other human beings inside the structure at the time of the burglary. So I find that you are guilty of all 4 of the counts. Is there anything that the courts missed as far as factual determinations?
To be clear on count 3, Your Honor, saying that he the way it's charged is burglary of dwelling with assault or battery. So to be clear, the court is finding that Mr. Scott committed a burglary of a dwelling and within doing so committed a battery there in the residence.
Yes, ma'am. And right, in a residence, correct. Yes, ma'am. So as far as sentencing for Mr. Scott,
Judge, I have a copy of Mr. Scott's pen pack. May I approach?
yes, ma'am. Thank you. Thank you, ma'am.
I don't know if you want me to call that State's Exhibit 1 for sentencing purposes, or...
Okay. Any objection to it being entered?
No objection to the pen back.
It's admitted as State's Exhibit 1 for sentencing. Yes, ma'am.
Judge, with that pen pack and with the findings that Your Honor has just made of guilty as charged on all 4 counts for Mr. Scott, at this point, Your Honor has no option but to commit and sentence Mr. Scott to a term of life in prison based on count 3 of the burglary of a dwelling with a battery that is punishable by life. With the pen pack, the state would argue that he qualifies for sentencing under PRR, and we would ask that Your Honor impose that. Now, on counts 1 and 2, he would also qualify as PRR. But those all 3 will need to be run concurrently, so run at the same time. So it would be a 15-year sentence on count 1 and a 15-year on count 2. But again, all of that will run concurrently with count 3. The state would also ask that on count 4 that Your Honor, in its discretion, impose, it's not a PRR sentence, so he would be entitled to gain time on count 4, but we would ask that Your Honor impose the maximum of 5-year DOC sentence on count 4 to run at the same time as the other 3 counts.
Okay, and the 15 years, are they concurrent with each other in counts 1 and 2?
Yes, Judge.
Okay.
All counts would run concurrently.
Okay. Mr. McKinney?
Judge, the defense really can't make a defense argument if the court does find Mr. Scott to be a prison releasee reoffender. And based on that statute and sentencing enhancement, the court would look to the pin pack presented by the state in determining the time period whether or not Mr. Scott qualifies. Certainly the defense is not stipulating that he qualifies as PRR, that would be a court determination.
Yes, sir. Thank you. The court does find that Mr. Scott qualifies as a prison releasee reoffender. Mr. Scott, you're adjudicated guilty. You're sentenced to, as far as count 3, life in prison as a prison releasee reoffender. On counts 1 and 2, as a prison releasee reoffender, 15 years each on those counts to run concurrently with each other and with count 3. On count 4, You're sentenced to 5 years with the Department of Corrections, with credit for time served on that count, but that will run consecutively to the other sentences. Mr. Scott, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights? Mr. Scott? Mr. Scott?
I hear you, sir.
Okay, you understand your appellate rights?
I understand.
Okay, thank you, sir. Court is adjourned.
All rise.
Yes, sir.